Hello. Hi, Elsie. How are you? I am going to go through the second part of the pre-hearing trials. I know there's a lot of talk with the new unsealing, and perhaps this is kind of old news, but I know some people were still waiting on it, so I'll go ahead and share it. Hi, everyone. Hi, Mary Nash. Hi, Christina. Hi, Matcha Latte. Hi, Heather. I finished the presentation for. I'm gonna remove myself for the second half and wherever we stopped last time. So I'll pick up from there. But I did want to share an update. Hi everyone, thanks for joining. I did want to go ahead and update that I have not posted the latest drop, which was the one from May 1st with all the recent unsealings. However, I did update all the depositions. So if there's new deposition pages, let me see if I could share that with you guys so that at least I can show you that part. Okay, let me share my screen. Okay. Oh. Okay, so here goes. So if you go under the the depositions page at the top, this should be your new view. I went ahead and left the plaintiffs. I'm going to add Jamie Heath's through Wayfarer deposition up here, and I'll make it under Wayfarer, like the little logo. But I did want to, with the interview that Brian Friedman did, and he's like, look, this is the biggest update to the case, is that they are no longer parties to this lawsuit. I thought I would update the deposition page to reflect that. They're non-party witnesses at this point. So I left Jennifer Abel because she has the lawsuit with Stephanie Jones, but I went ahead and put everybody else in the non-party witness area. And I've updated a lot of the depositions that were from this round of the unsealing. So you'll see Steve Sarwitz, Melissa Nathan, Katie Case, Ange Giannetti, Justin Greystone, Laura Tedesco, Josh Greenstein, and a couple of the experts. I updated it today. The Haggerty one, and Anne Fromholz, and Jeffrey Kenrich. So I've updated that for you guys, so you feel free to check that out. When you click on the deposition, it'll take you to the updated document, and the pieces that are new will be highlighted. So, for example, for Josh, let me see where the new ones. Okay, so his new pages are towards the very end. Let's see. 250. Yeah, so somewhere back here, you'll see the highlighted pages. There you go. So you'll see what's been added, and if you want to take a look at the continuation of the depositions. Josh, yes. I love how Bocce says that. I think she's caught us all with that. So all the depositions have been updated. We're still waiting for Wayfarer to post their unsealing, and hopefully I will update that when we get that as well. So, okay, let me jump into the back into the presentation of this. Okay, so Fabian, he essentially went up to the court and said that there was an issue with Culotta and Mayzlin's reports. And he said that his main defect, sorry, my nose, it just, his main defect with both of them is that there's an analytical gap between the types of method that they used and the conclusions that they reached. He did mention a case. I think I spelled that right. And he said, expert conclusions must be reliable and follow methodology that's previously used. And that's going to come back up in Gottlieb's arguments against that. But that's an important thing to remember. Like, he's saying that they should use patterns that they've used in the past. And then the judge, and neither identifies any reliable indicator or reliable test for manipulation of social media. In my notes for that, I put unusual doesn't mean manipulation. And I think that was because I felt like that was the theme of his arguments. Unusual, and it'll come up in the next slides. Expert analysis under Daubert has to be reliable. And so if they're claiming that manipulation was detected, then the method to do that has to be a reliable method. And so the judge asked him, are you asking me to exclude the entire thing or the manipulation causation parts of their opinion? And he essentially said both. Like, he said both. And then the defense is seeking to exclude evidence of negative manipulation entirely, doesn't think anything is admissible. So that's Fabian's argument. Fabian continues, and the headline of this slide is unusual does not mean manipulation. So he said, even if we assume anomalies or deviations from the norm, that does not mean it's probative of manipulation. And then he mentioned a metric that he used, which was the Twitter follower for follower metrics might indicate inauthentic activity, but doesn't clearly establish that. And he says that even though there's deviations from the norm, that doesn't mean it's inauthentic or manipulative behavior. And then the judge asked Fabian, he says, Culotta focuses on the number of likes of a comment as opposed to the post. So if you guys remember, they were making arguments that the comment had more likes than the post. And if that meant it was equal, or my abbreviation of it, like, does that mean that's efforts to boost? Does that signal that there's efforts to boost the post, given that that's how the algorithm works? And Fabian replies with that Culotta does not say in his findings that it's inconsistent with organic activity. So he's making his methodology needs to show that it's needs to show that it is inconsistent with organic activity, and he can't show that. Carol mentioned that happening to her before in the comment, and she made it. I don't know. It was a thing. What are you guys talking about? Sorry, I missed the conversation. Let me see if I can go back up. Hi, Rachel. Hi, Jessica Lisi. Okay. Your comment had more likes than the original video. Oh, yeah. I remember that happening with the video of Kayla Nicole. My comment had way more way more likes, but now the video has way more likes than my comment. Oh, sorry, Mary, that you're not feeling good. Allergy season is kind of bad. It's evening time over here, but I'm glad everybody can join. Okay, so then again, he just continues to say that Mayzlin and Collada cannot scientifically distinguish organic from inorganic. And that's one of the reasons why the judge, I think, is going to have that Daubert hearing and test how they're going to present their information. Highlighting again, anomaly does not equal that the defendant did anything bad. The data set has no baseline comparison. For example, like they said, they didn't use other celebrity conflicts to show that would kind of mimic in other celebrity conflicts. They didn't show that. Statistical deviations alone are too speculative and prejudicial to defendants. So that is the Fabian's stance for the defendants, is like this will hurt the defendants. It will be prejudicial to them for their methodologies to not be reliable and speculative. And then the judge asked what I deem to be a catch-22 question, which if you guys remember, like he said, like they should use methods that have been proven or used in court or that are reliable methods used in the past. So the judge says, if you want experts to identify manipulation they've seen before, but manipulators are always improving to evade detection, wouldn't that prevent somebody from ever showing that there was a sophisticated manipulation? And he made a comment like at arm's length, if manipulators are always like at an arm's length. And then Fabian said, there's a second circuit decision. And I like this line because he said the courtroom is not a place for academic innovation, scientific innovation. It's academia that leads the law, not vice versa. So it shouldn't be presented to the jury as reliable, meaning, sure, that may be the case, but in the court, during trial is not the time to do that. Okay, let's see. Then Fabian went into Mayzlin's arguments. My headline of it is nested opinions, many coincidences. And there's a line in here as to why he called it nested, because if she has this one thought and everything's based on it, well, let's just read it because it's in here. I put it. Mayzlin offers no scientific link between defendant's conduct to harm and harm to Lively. And I put, quote, a nested set of opinions, all of which depend on the first opinion, which is that defendants caused the manipulation. And she relied on the scope of work letter and like themes that came up in that. And we'll go through the bullet points of how she made those connections on there. Hi, everyone. Okay, so I'll continue. If you guys have questions, just let me know. If I missed it, just okay, so it says report shows a slight uptick in negative posts, a small percentage of posts that contain themes reflected in the scenario planning. That was Mayzlin's I guess main point that comes up in this hearing. So I'll just continue reading because it'll make sense as I go through the things that I wrote down. Mayzlin infers causation from the timing alone. That was Fabian's argument. But he said it also coincides with many other events. He said the rift between Baldoni, the cast unfollowing him, Baldoni being excluded from the marketing. He's like, and she takes none of that into account. She just takes the scope of the scenario planning and the slight uptick of negative posts and deems it correlated. And in the slides, it'll come up where he says, like, a expert must show that there was no alternate reasons, like that they explored those alternate reasons and that those alternative reasons could not possibly be the cause of it. But we'll get to that. It says, plus the hair care release. And then the NYT did an article about how Lively cross-promoted this DV film with her alcohol brand, and that could also be a reason for the uptick in comments. Then they reference page 96, and I put it here in quotes. It is my understanding, because this is what Mayzlin wrote in her report. It is my understanding nothing else happened in August of 2024 that could have explained the phenomenon that I measured. And that's what Fabian is saying, is like, she didn't consider the things that I just mentioned. And that comes up again because the judge asks again. And he says, alternate causes, Mayzlin ignored. I guess that was my takeaway from that. And then the judge asks, such as, and Fabian's like, the ones that I just said, the premiere, the cross promotion, the serious film. And I remember him saying, with cross promotion with her husband's superhero film. And when you put it like that, it's just such a jarring contrast that you could see why people would be upset of why Lively promoted it a certain way. And then he mentioned again the rift between Lively and Baldoni, like that was becoming obvious to people. And then I think he's wrapping up. Oh no, he has a little bit more. He says, the expert is required to exclude alternative causes. Okay, so here's that point that I was mentioning earlier. They're required to exclude them. So in order to exclude them, they have to do a rigorous analysis to exclude them. And because she said it is my understanding that nothing else happened in 2024, that's why Fabian is making that argument, that's saying, well, she didn't do a rigorous analysis on those other things that could have caused that uptick in negative comments, negative posts. And then he mentioned about AI classifying negative social media. And I put not only post negative to Lively, but anyone, because he said that the post, even if it was defending Lively, but said something negative about, let's say, Baldoni, it would deem the whole post as negative towards Lively. And so he had an issue with that as well. Hi, everyone. Yes, so I like this comment. So that was the theme. Her experts did nothing to rule out other causes. And that's the argument that Fabian kept making, that they have to. It is their burden to do so. Hi, Rosewild. Thanks for joining. Okay, so he continues on. I think we go into Mike Gottlieb's arguments. He said the judge asked if the defense was challenging the use of AI or the way that the AI understood instructions in this case, and Fabian answered both. He said the classification of these posts by AI is the basis for Mayzlin's opinion. Mayzlin uses AI, a large language model, to classify 1.1 million posts. He says we have no way to know how many of those 1.1 million posts are wrongly tagged, but in the small analysis of the ones that they did, they found that some of those were misclassified, that even though they were negative towards Justin, it still marked it as negative towards Blake. At least that was my understanding of it. and maybe I should put in a disclaimer, I'm not an attorney. I'm just sharing my experience of the pretrial hearings and putting this presentation for you guys to help you easily digest what I digested from that hearing. So hopefully it's helpful. The clicker pen method. Oh, okay, yeah, that's a good idea. So for those that weren't on Bocce's live, she mentioned something about being in court and how, like, you know, she's not sure if she will be good at taking notes. And what I did the first time was I just took like my favorite pen, but it was really hard to distinguish after I had left who was who and who was saying what, because it doesn't give me time to like write their name or like make that distinction. So this time I had a pen, a clicker pen that had five different colors, like blue, black, green, and red. Oh, four. So I had four, and I used one color, red for Lively, green for Justin's attorneys, and blue for the judge. And that really helped me see where the judge spoke, where Lively spoke, where the defendant spoke, where Wayfarer spoke. And then in black, I would do notes like if the courthouse laughed, I made a note, like I put LOL, and I used black, so I would know like that's my observation. No, I didn't see your question, Mary Nash. Let me see. This one? Oh, Fabian. That is Fabian's argument. Fabian's argument to the court is saying, Judge, her experts carry the burden of having to prove that these things are connected, but they're also, I guess the way that I understood it is like they're also responsible for ruling out other causes, and they have to analyze these other causes. And that's why I wrote in here, like, they have to do a rigorous analysis to exclude them. But how could they when Mayzlin herself wrote in her report on page number 96, it is my understanding that nothing else happened. And he's like, girl, the rift happened. The cast unfollowed him. He wasn't allowed to be in marketing. NYT wrote an article of Blake Lively and the odd cross promotion between an alcohol brand and a DV film. The hairline released and how people were upset about that. So it is their job to analyze these other causes. And she's saying nothing else happened. So that's why, yeah, okay. I did answer it. Okay, good. So that's what Fabian's arguing as to why to exclude them and why the judge is going to have them at the Daubert hearing next Friday. Okay, so we have no way, of seeing these 1.1 million posts. And then he finishes off with the line, which is, it is Ms. Lively's burden to show by preponderance of the evidence that each step of her analysis is reliable. And they are arguing that it is not. So one of the themes in the scenario planning is Lively wanted to take over film and credit. And Mayzlin just connected that and said, oh, that's retaliation. But the court already said that that is a reasonable defensive measure. But she treats both as harm to Lively. And then there was an argument about like how much damage came from what, like non-actionable versus actionable. And that theme is going to come up a little bit later, but that is brought up here again. Okay, let me see if I can move forward. Okay, Gottlieb. Let me see if I missed any of my notes. Okay, yeah, one thing that I noted here on my side note is Fabian said, Mayzlin doesn't do analytical work to rule those alternative causes out. And I put in quotes, she just surmised at the deposition that the defendants caused it. And that's not according to his arguments, that's not reliable. That's not science. That's what Fabian argued. Okay, so now we can move on to My Gottliebs. Does anybody have any questions up until there? Oh, thank you guys. Thanks, Lori. That's such a nice comment. Hopefully this is helpful. And sometimes like I took my questions to chat. Like I would say like, oh, break this down. Like I think I got the gist, but I need a little bit of help too, because again, I'm not an attorney. I just do my best to like however I understand it. And so hopefully my additional way, like how I can explain it too, helps. Who said that, Carol? Okay, so everything I just said was Fabian's argument, which is Wayfarers, it ends with us, tags, attorneys, all up until now. So that, and if I said the judge asked this, the judge asked that, that was Fabian answering. I'm going to check if there's any other questions. Okay. So now we're going to go into my Gottlieb's. And remember, so the attorneys have 15 minutes. So Fabian here, he had 12 minutes, and he said he wanted to reserve 3 minutes for the end. So all the slides that we just reviewed, that's all his arguments. That was his 12 minutes. Then it goes into Mike Gottlieb's, and Mike Gottlieb has 15 minutes. Something that I didn't put in the slides, but I thought it was kind of neat from Gottlieb is he would refer to Fabian as his friend. He would say, my friend said this, my friend said that. And the judge was trying to be like, your adversary is making points. And Gottlieb was like, my friend said this. Okay. All righty. Mike Gottlieb is talking about the standard, and my highlight or my topic of this argument is that he believes that they're allowed to use a hybrid methodology, and I'll go into what he says and why he thinks that. Okay, it's like, I think they do that a lot. My learned friend seems to be the thing at the attorney world. Okay, yeah. You know what? Yeah, I would imagine that, because they were actually really cordial and nice to each other. So I guess that's a good thing. Okay, so the Gottlieb starts with the case law allows experts to combine methodologies. He says they're allowed to include hybrid approaches, and he cites a case law, but I didn't get to write it down. And then he says experts are not required to use only previously used methods. And if you guys remember, that was an argument that Fabian made about like, hey, they got to use previously used methods. Gottlieb is saying, no, they're not. They're allowed to use other methods. And if you guys remember the judge question about like, well, how would they use previous methods if the method is always updating, right? Because to catch inauthentic activity or the way he said, I think, is manipulators, they would always have to be at arm's length, right? Like right behind them to do it. Okay, so then he said that the defense never challenged the qualification or the expertise of their two experts. And he immediately attacks Nicole Alexander and says she has no qualifications to opine on what she opined on. And the defense never challenged Culotta's the data set. And that's going to come up in Fabian's response. He'll address some of these things in his response, but for now, he's like, they don't challenge Culotta's data set, 1861 TikTok videos pulled through the API. He said that the comment section of social media post is a way for a nefarious actor to engage in an algorithmic manipulation. So Gottlieb's argument is the nefarious actors do their thing through the comment sections. And then also remember this TikTok video pool, okay? Because that's going to come up in an argument against him later down the line. The judge asked if Culotta cited more than 3 studies, and Gottlieb just said those 3 studies, and he's like, oh, I don't know, if I happen to remember them while I'm still up in the podium, I'll tell you, but he couldn't remember more than the 3. And this is why I said, like, the judge was very, very familiar, and I remember NAG and LGA saying, like, this is a really good judge because he's very familiar with the case. He's not like, what was that again? He knew this number. He said, does he cite any more than 3 studies? Like, he must have had that in his notes. And then Gottlieb was like, no, right now it's just 3 studies. If I remember anything else, I'll tell you. Okay, and then he went through some stats, and the stats were pre-August, anti-Lively top comment share was 1.7. Post-August, anti-Lively top comment share was 21.5. And then the judge asked him, because he said something, let me see if I wrote it down over here. Because okay. I said, okay, so he said, Gottlieb said that the professor calls that, and I quote, a statistical significant deviation that is indicative of, consistent of, manipulation in the comment sections of TikTok. So then the judge says, you just said indicative of and consistent of. Are those different? And Gottlieb responds, it's indicative of and evidence of. But Culotta does not claim to prove causation. Yeah, Gloria, I like your comment. He said we're all nefarious actors. That he thinks that we're on their payroll. And he's like, I think Johnny Depp also owes me. That's a funny comment. Hi, everyone. Hi, Prickly. Okay. Okay, so then he goes on. Let's see. Okay. Okay, so the reason I also noted here, because this is what I Googled, why the judge might ask that. And my notes from like my search is like, well, the judge could be calling that out because under the Daubert standard, words matter. Indicative of, suggest evidence pointing to something. Consistent with just means not inconsistent. And those are very different scientific claims. That's not from the hearing, guys. That's something that I Googled as to why the importance of that distinction. So I Googled that. And so that's what Google said. Yes, words matter. So that's why he was like, is it indicative of or consistent with? Which one? And then Gottlieb ended up replying indicative of and evidence of. So he took away that second sentence. So, and then the court asked, isn't it an equally fair inference that the mass, and this is, I don't remember, I just wrote down that the mass audience didn't like Lively organically. The mass audience just developed a negative view of Lively organically. And Gottlieb says, there was a comment in a Daily Mail video on August 9th that Ryan Reynolds wrote whole scenes. And that's the same time. So he just replies with instances where something happened on social media that lined up with text messages that tag sent. So he's saying that's also some sort of tag message where they noticed this comment. I don't know. I probably need to verify, but that's what he says. And then he's like, Katie Case texted, thank the Lord for social and digital mitigation. And then he says, Katie Case also testified that Ryan Reynolds' rewrite narrative was discussed with Jed Wallace. Okay, so Okay. I'm at the Fabian PowerPoint. Okay, so you're a little bit behind, but their delivery. I think that Fabian was very clear. He was very concise whenever he was delivering. I was able to follow him a little better than I did Gottlieb. And Gottlieb got shaky, but not in this part. Yeah. Okay. So then they move on to analyzing 9,000 posts from Reddit's own comment scores are unquestionably relevant because Reddit has a built-in score system for their comment section. Like you can upvote and downvote stuff. So he brought up like that they also analyze that. That's all I wrote for that. So I don't know how he's connecting that. I just wrote down that. Little Bump video was uploaded August 10th, and he's arguing that they didn't see a spike until August 14th. But I don't know if you guys saw the Kirsty Flaw video about her analytics going through that, and she's pointing out that it just doesn't line up with what they're saying. Hi, Christina. Thank you. Social digital. I like this comment. Social and digital mitigation can just mean us regular people responding to their BS. Yes, I agree. Okay, then he said bully-related items jumped immediately after tag said send to Jed, and I put on August 4th. That was on August 4th. But if you guys remember, Naomi Rim argued that it didn't even start till August 10th. So I don't know how that fits in, but I'll move on. Post August 14th, he said 700 total bully comments. One more. Okay, sorry guys. I have to pause real quick. I'll be right back. Give me just 1 second. Sorry, guys. I came back. I had an emergency in my house. Okay. Then he said that those bully comments had 10.4 high engagement comments after, and I noted he called it a temporal fingerprint. Oh, thank you, Just Khaleesi. Hit the like and the subscribe. Thank you. Thank you, everyone. I appreciate the exposure and for letting me walk you through this. Give Docket Hubby your guys' love. I will. Okay, so Rachel has a really good question. Do you have the analytics showing the proof of manipulation from the expert or just chart with spikes? I don't have it, but in the website, I did attach the reports. There's like 2 reports that I'm missing adding. So let me just show you guys that real quick. Let me remove this and add this. Okay. If you guys go to the experts, I attached their report. I'm missing Nicole Alexander's. I'll add it here. And I think I'm missing hers. I'll add it. I think I did see that it was posted, so now I'll add it. So I'm missing these 3, 1, 2, and 3. But everybody else's report, if you guys want to see it or if there's references to it, you guys can go on to the depositions page and then scroll all the way to the experts and see it there. Okay. All right, so Mr. Dockett, that's funny. Okay. So Mike Gottlieb continues because remember Fabian made that argument about AI classifying this stuff incorrectly. So then he says attacks that the only arguments defendants are making is a temporal relationship apart from the AI comments. He said AI is a preferred method for classifying this volume of data, and the error rate is less than 1%, an acceptable rate. Mayzlin analyzed 1.1 million conversations from May 2024 to February 2025. And he said 2 key observations were spike in volume that occurs in August and a distinct spike in negative sentiment. Then the court says, aren't there all kinds of things happening that during that period? I'm sorry, I didn't put that in there. During that period that could cause a spike. He asked something like that, but he said, aren't there all these kinds of things that could cause a spike? And Gottlieb says, yes, he'll address that in a minute. And I'm like, no, address it now. The court wants you to answer that now. And he said, yes, I'll address that in a minute. But that's a question for the jury. And he says, her report describes the defendant's course of conduct caused the spike in negativity or would have. So essentially they want to say that that's a question for the jury, not the expert to argue. Yeah, do it now. Exactly. The judge was like, couldn't there be? And he's like, I'll get there to a minute. And honestly, I don't think he got back to it. I don't remember right now, but perhaps let's keep going because if he did, it'll be in here. The judge asked if there's something other than page 64 in the report, or is there anything else that considers an alternative or an alternate explanation? And Gottlieb says, apart from page 64 and 65, and he's like, I don't know. I'll let you know if I remember or something like that. Mayzlin's observation about small percentage of themes that come in the conversations do not exist prior to August 2024. So he's making a statement that the scenario planning document and the themes that come up there, he's saying that didn't exist prior to August 2024. But as we've seen with deep dives that content creators have done, that is not the case. They pulled up Bully, Tone Deaf. You guys remember Kashmir Chronicles, Ken's, Bocce, like they all covered this, Katie and Casey, that they had these comments that there's articles that did have those themes from like 2016. But they're saying, oh, that didn't exist prior to that scenario planning document. The themes are bully and mean girl. He left out tone deaf. And then he said, Mayzlin said after the campaign launched that those themes rose to 4%. Oh my God. I thought it was going to be a super high spike, but they only rose 4%. And he's like, and then they rose again. So after the campaign launch, I think he's referring to the scenario planning, and then 10% again after. That's not a big spike, at least not in my point of view. This question, did Jed have any deposition about that sent to Jed? No, what they're referring to is the text message whenever they have articles. If you guys remember, Katie Case will say, send this to Jed, make Jed aware that this is out there, like send to Jed. And so that's what he was referencing, that there was that, I think it was a Ryan Reynolds article or the comments under the Daily Mail tag. And then he said, oh, sent to Jed. That's what it was referring. That's what he was pointing out to. At least that's what I took away from it. And then my final point here is the whole point of the comment manipulation is to have people see the content that they wouldn't have otherwise seen. So he was making the argument that algorithmically, the comments is how you get more eyes on this negative comment. And I posted in NAG's video that actually, if your algorithm is like, I don't know, the best example I can give right now is like pro Taylor, and you see a video, most likely the comments that you will see are going to be what aligns with your worldview on Taylor or worldview in general, because that's how the algorithm works. But if you maybe have said something not so great, or maybe you've looked up, I don't know, bad songs by Taylor Swift, maybe your algorithm will show you comments that are negative about Taylor Swift. So I'm not convinced on that argument, but nobody's asking my opinion. I'm just sharing it. Okay. And then Mike Gottlieb continues on with the Alexander arguments and why he wants to exclude Alexander. And then he said, okay, defense expert Miss Alexander filed a corrected declaration after errors found that should be excluded under a rule. So apparently she had made an error and she filed a declaration, if you guys remember, and they're saying that the court accepting that declaration now would prejudice Lively because they didn't get to ask questions in her deposition about it. And so they're trying to get her declaration out. And Fabian does make arguments against that, and we'll get into that in the next slide, but that's what Gottlieb says. He really does not like Alexander. Because if you guys remember, like he doesn't think that she's qualified to make the opinions that she did. He says she used the wrong underlying data in her meta-analysis and had to supply this new corrected data. And they mentioned Bader sentiment. I had to look that up because I actually wrote Bader because I thought that's Bayer sentiment, not Vader. And analysis introduced, and he's saying like that wasn't disclosed in the original report, and now it is, and they have a problem with that. And he's saying Alexander's core opinions on temporal synchronization was backwards. I don't know what that means, but that's what he said. And then the court informed him he was out of time. He was like, hey, you're out of time. So he only spent a little bit of time talking about Alexander, and then the judge had to cut him off. Yeah. Gottlieb doesn't like Alexander. Like he said from the beginning of his presentation one of the first things he says about her is like, oh, the defense never challenged our experts' qualifications. And by contrast, we're saying Miss Alexander has no qualifications to opine on what she opined on. And that's their stance. Okay, so then hopefully that answers the question. Mary Nash. I'm sure it was strategic to not have Ezra do this hearing. She'd be screaming to take up her precious minutes. She'd argue she'd want 9 minutes. Okay. Okay, so now this is Fabian's 3 minutes. I think he does get cut off too, because he's like, hey, do you want to finish that sentence up? And I think he gives him like 15 seconds or something, or a few seconds. Yeah, okay. Yeah, I do remember, and I did write that in there. Okay. Let's go to that report. Okay, so this is the defense rebuttal. He's saying, Fabian, and this is Wayfarer's attorney now, and again, he was very clear in how he communicates. He has a very like crisp voice when he talks. He sounds very, very clean cut type of look, and how he speaks is it's nice. So he says, and eloquent, like that's the word I was looking for. He's very eloquent. He says, this is not for the jury to sort through, because if you guys remember, Mike Gottlieb made those arguments that, oh, we'll let the jury, rummage through that. And he's like, no, this is not for the jury to sort through. The courts routinely exclude causation experts for failing to consider alternative causes. So he hounds back to the same points. Counsel says that these negatives were completely absent before 2024. So he's talking about Gottlieb saying this. He's like, they say that these themes didn't exist prior to August of 2024. And they're like, that is not the case. The report doesn't say that. He said the data itself has examples of lively, and this is where he brings up lively bullying Princess Catherine when she posted a Photoshop photo on social media. So he's like, that's clearly not right. That's what the data shows. And so Gottlieb saying that these bully themes did not exist prior to August 2024 is simply not true. And the argument that defendants don't, so if you guys remember, Gottlieb's like, oh, the defendants don't argue that our data is wrong. He's like, Gottlieb says that we don't challenge Culotta's data, but he's like, but Mayzlin does. And the reason he says that is because Mayzlin believes that TikTok is not a reliable platform to collect data. So he's arguing that Culotta extracting data from TikTok and analyzing it, and her own experts saying that's not a reliable way of doing it. He's saying Lively's own experts contradict each other. And then they brought up this Kindermere report, and it's interesting. I think he says, but does not claim to have. Okay, I remember. They brought up the Kindermere report because that is something that Culotta references. But he's like, the Kindermere report doesn't claim to have done anything near what Culotta is claiming to have done. So he's relying on this report, but saying like it's not doing the heavy lifting that Culotta is doing here in his report. So that's, I guess they don't believe it's proper. And then says Culotta shouldn't walk the jury through the narrative of the documents. That's improper. So he was arguing that, Culotta was going to show these text messages and these themes, and that's what he's saying. Like, he shouldn't walk the jury through the narrative of those documents. That's not up for him to do. And he just, again, he doesn't think it's reliable. He doesn't think it should be done to a jury, and that's the argument. And then I put why August 2024. He says a lot of things happen, and then I put in parentheses, he ran out of time the judge asked him if he wanted a few seconds to address the points that he brought up on Alexander. And he just says that the declaration is proper and that making any corrections, like, it is allowed per the rules. He says it is allowed. So he's like, that's where we're at. Okay. Yeah, okay. And my note about Mayzlin, she said that TikTok is not a platform from which you can collect reliable and representative data set. So both of Lively's experts are at odds in regards to TikTok. I thought those were really good points. So do you guys have any questions up until there? Because now we're going into Ellen's 15 minutes, and this is talking about the retaliation and Brian Friedman's comments, so it's a completely different topic. Okay, let's see. Okay. Yeah. Okay. So we'll move on to the next comments that were brought up. Okay, so Ellen, she goes through a little bit of a timeline. Hi, guys. Hi for anybody just joining. We're going through the pretrial hearing notes and statements and opinions. I'm not a lawyer. I'm just a girl that was at the hearing and took a bunch of notes. And then Googled stuff to come back and say, well, how can I explain this to people? So hopefully it is helpful to you guys. And I will make the presentation available on my website, the docket updates, once I'm finished going through it. So I'll keep going so we stay on track. Okay, so she goes through a brief timeline. She's like, Lively filed the CRD complaint in December and in 2024, and then the lawsuit December 21st. Wayfarer filed she said, for all intents and purposes, what's called a counterclaim. And the reason that stood out is because NAG, if you guys remember, when they had originally filed their lawsuit, she was like, guys, it is not a counterclaim. Don't call it a counterclaim, because it was a lawsuit in itself. But for this purpose, she's like, for all intents and purposes, it is a counterclaim, and it should count as a counterclaim. So that's what I took from that, and that's what I remember. Tension between, she said something about, okay. She said there was tension between the First Amendment right to petition and the interest of protecting the plaintiffs in discrimination lawsuits. So what she was referring to there is that law, the 47.1, and she's like, there's tension in that law between, First Amendment rights that people have to defend themselves and, protecting someone that's making discrimination claims. And she ultimately said the First Amendment prevails because of the case law. And the defendants have the right to bring a cross complaint. And then put standard of complaint is not okay. So she harped on, the standard is that the complaint is not retaliatory unless it is totally baseless. And Wayfarer's complaint was not found frivolous because the court allowed them to amend two of those claims. And a word combo that she used that really stood out to me was this next sentence: powerful evidence that Lively provided the CRD complaint to NYT, to the New York Times, prior to filing. The court dismissed their claims relying on an unpublished case. And I think the reason she brought that is for the following. She says, the issue has not yet reached the appellate courts. I think she's trying to say, in my opinion, what I took from that is like, you dismissing our case on an unpublished case, that's a little bit weak, because it hasn't reached the appellate courts. If you dismissed it on an unpublished case, and NEG did a really good video, may have been LGA, about the strength of like using published cases versus unpublished cases, and that was a really good video. If I find it, I'll put it in the description of the video of this YouTube video, because I think that that's really helpful just to know. And I think that's why she brought that argument. This court noted that, and she said, unsuccessful complaints are not the same thing as baseless ones, and they're still entitled to immunity, or what I take as privilege, right? Litigation privilege. And then she went to start talking about Rule 11, and the judge said, don't spend your time on that. So she did talk a little bit about it, but she didn't say much. She just said that Rule 11 and the rules for an actual case, like, they have different standards. One of them is objectively basis, and the other is objectively unreasonableness. But again, the judge told her not to go into that, so that's as much as she says on that. Oh, and Ellen was just so masterful. She didn't use a lot of her time. It was very clean and concise how she presented, and she was, she just commanded the room. That's how I took when she spoke. She was just laying out her arguments very cleanly, very concise, and very confident. I really liked her. She had this like blue, what looked like linen, like a blue linen dress with a little bit of a slit, and some coat shoes again. She was really cute. Yeah. Okay. And then she says Brian Friedman's comments were post-litigation and post-filing. And then that was it. That, like, the other people spent like 3 slides. Ellen just like came in, and she only used 5 minutes to make those arguments. And then Gottlieb went into his arguments and said there's 2 pending motions. And my note here was, I don't think Lyman buys into this, and you guys will see why. I broke it down into all these slides, how he kind of tackled it, into these 2 pending motions. But Lyman was giving him a lot of pushback and a lot of like, I'm not so sure. Your adversary makes really good arguments, and this is where I saw Gottlieb a little bit like, no, you're not understanding me. This is what I'm trying to say. And he's like, no, I understand what you're trying to say. It just doesn't make sense. Like, that was the vibe. That was the vibe of this argument. So he says there's 2 pending motions before the court. That's how he started. He didn't like go into attacking the arguments yet. He was saying like 47.1 of the California Civil Code says that the defendant's lawsuit is retaliatory and barred. And he said that, barred. And then he said lively CRD filing and her speaking out, he's referring to her speaking out to the New York Times, is protected by California law. Defendant lawsuits is in violation. That's something that he pointed out. Let me bring up this question. Carol, did Lyman have a response to Ellen when he said you dismissed the NYT case on an unpublished case law? No, he didn't say anything. She just did her 5 minutes, went over the points that we went over, and then she was out. And she had 15 minutes. And actually, the court asked her, do you want to leave time for a rebuttal? And she's like, yeah, I'll leave 5 minutes for rebuttal. But she only used 5. So you'll see that in my notes later on. The judge's like, hey, you only used 5 minutes. You can use 10 now. Yes, it is. I mean, it was a very good hearing. Okay. You said filed on the 31st, or am I just wrong? I wrote 21st, so, but you could be right. I mean, I was writing pretty fast. But I think it is the 21st. I'm pretty sure it is, because the New York Times article I think came on the 22nd or like the 21st at like 12 or something. If you guys remember, I think it is. I think that is right. Okay. So then the court, this is when Judge Lyman says, your adversary makes quite powerful argument that they are not powerless. That's how he responds to Gottlieb. Like, it kind of stops him in his argument and says he makes this. And then he says something about Lively. He's like, if Lively leaks to the New York Times to say something that is untrue, like they have, you know, that they are not powerless. Like, I think that's what the court was trying to say. No, that's it has not been asked, but it is on the calendar on docketupdates.com. Under calendar, I have when they have to unseal those documents. I think it's May 4th. Hold on. Yeah, I think it's tomorrow. I think it's tomorrow. Okay. All right. So then he goes, this is what I described as the judge's pressure test. And this is where I had like a lot of questions for ChatGPT. I was like, wait, why did the judge say this? Like, why did the judge bring up this point? Just kind of help me break it down for you all. Okay. So, and again, I'm not an attorney. I do have to disclose that. I'm not an attorney. I just went to the hearing. These are my notes and how I went about sourcing this information and trying to put this document for you guys, this presentation for you guys, and to make it available if you guys were interested. Okay. And the judge says, if I rule for you, and remember, this is because they don't want Gottlieb and Blake Lively want to bring in the cross complaint into evidence. If you guys haven't seen content creator comment on that, I think NAG and LGA did a video on that, but they are trying to bring that cross complaint into evidence to say, look, this is retaliation. And the judge said, if I rule for you and allow you to do that, essentially, he said they would have every right to put out evidence that Lively is a liar. That's what he's saying, because and again, this is all for my independent research and trying to figure out like, how is this important and how does this play in, and then watching NAG's videos and LGA's videos and Britt's and Teresa's. What I gather from this is ultimately Gottlieb is arguing, if you guys remember in the first slide, that this is retaliatory and barred for them to even bring that cross complaint. But then they're saying, well, let us show it to the jury that this is retaliation. Let us show this cross complaint to the jury that it's retaliation. But if they show it to the jury, then now the other party, which would be Wayfarer, it ends with us and Tag, would be up there saying we had all right to bring these claims and put evidence that Lively is a liar, because they would have to talk about why they even brought a complaint in the first place. That's what I ended up gathering. And then the judge continues, the court continues, we would have a trial with respect to all those issues. And I think I wrote I think he said slideshow, like we would see this would be a whole sideshow. And then Gottlieb was like, that would be fine. He was like, yeah, sure, that would be fine. But guys, they're making an argument that them talking about this is retaliatory. But then if they go and talk about it in court, like that doesn't make sense. If they're allowed to talk about it, then it can't be retaliatory. I guess in my brain, it's making more sense now, because they're saying this cross complaint is retaliatory. And the judge is like, yeah, but if we bring it in, they get to talk about this. And then their actions are not retaliatory, right? Because then they have to say how Lively is a liar and prove all this stuff. And he's like, but, so Gottlieb's like, that would be fine. But then he's like, but I think that this isn't the case, because he brought up the Rule 11 finding that at least some of the claims, and if you guys remember, some of the claims were, they didn't get sanctioned, they got reprimanded, right? They were like, oh, this is close to sanctionable, but I'll reprimand you. If you guys remember, because some of the claims, remember, it was Steve Sarowitz, Melissa Nathan, and essentially anybody that's not Wayfarer shouldn't have been brought on all of the claims, but they made it like all the defendants are saying all of these issues apply to me, but they only applied to like It Ends With Us or Wayfarer. I think it wasn't even It Ends With Us. It was Wayfarer and Justin and Jamie, but it didn't really apply to Steve. It didn't really apply to Jen Abel. It didn't really apply to Melissa Nathan. From what I gathered from, this is not from the court, this is from like just watching content about this and about the reprimand, right? And so he's saying, so this is Gottlieb bringing in that, and that's how he says it, like the Rule 11 finding on at least some of these claims. And the court says, okay, but Rule 11 is quite stringent standard on what is objectively basis. And then he said, I would have lawyers testify that this is reasonable, that this cross complaint, meaning that lawsuit that they brought, is reasonable. And then Gottlieb said, this is where I felt like he was, my note was like, he felt like he was resetting himself, because he was like, he started a sentence, stopped himself, and then started another sentence. So that was my, in my opinion, takeaway, a little note on that. And so I put in here, he was about to start arguing the standard, and then he stopped and said, I think fundamentally my response, Your Honor, like he started a sentence one way, I didn't write it down, and then he changed it up. He's like, it's that why the issue is teed up for the court. He was saying it's fully briefed and waiting for adjudication. It's waiting for the judge to rule on it. And he goes back to saying lively CRD and comments to the NYT, that's what I think he's referring to, form the basis for the defendant's lawsuit. And he says Gottlieb violate 47.1. And Gottlieb cites a case and says there is no First Amendment value in a claim that is legally baseless or factually baseless. And then he brings up this case. I had to look it up because I spelled it wrong. I spelled it like Kohenga, but like Coenga. Anyways, but that's the case. He says, I regret not finding it sooner. And immediately I thought, oh boy, don't say that, because Ryan's going to come after you for not finding it sooner. But yeah, he goes, I regret not finding this sooner. And then he cites the case law. And that's all I wrote down. Fair wage, I wrote fair wage lawsuit, analogous to FEHA. I don't know what any of this means, so I'm just going to read it. A retaliatory lawsuit affects terms and conditions of employment even after the employment has ended. Okay, so he, what I remember is he talked about this fair wage lawsuit. He said what they did. He made a comment about it being an analogous to FEHA. And again, I don't know what that means. But essentially, what that case ended up saying is that that any lawsuit does affect terms and conditions of an employment even after the employment ended, because that's what happened in that case. Oh, thank you, Allie. Hopefully you guys are getting benefit from all of this. It did take me a long time to put this presentation together, so hopefully it is helpful to you all. Okay. And then he goes on to say, the intent of this lawsuit was to do more than just defend. And then the judge pushed back here, and he said something about so I put recovered damages for making false statements to NYT, and said, isn't that what the court permits? Let me see if I put anything else here. Okay. I guess my takeaway once I chatted here and looked it up, I think what they're suggesting is that the defendants can't even respond to public attacks, and that's the argument that Gottlieb is making. And then the judge is like, I don't know. I think it was like how they filed it. He said something about the defendants and how they recovered them. I'm not quite sure, guys, but that's all I have for that. But I think that is that what that court permits. I think what he meant was, like, does the court allows them to take the remedy measures that they can. I think, the court permits that. But then I put in here, the issue continues. Mike Gottlieb says, Gottlieb continues to rally. And I really did think that. My notes, like, he continues to rally, because ultimately what I took back from this is he kept making the same argument and with different words, but the same gist is what I took. And he's like, you dismissed it with prejudice. You dismissed their claims, talking about the defendant's claims, with prejudice. And he's like, they did not survive the motion to dismiss. And you already said that lively statements were privileged. Remember when he dismissed Wayfarer's case, Lyman wrote that into the dismissal. Remember that lively statements were privileged, and that Ryan Reynolds had every right to believe his wife and all that jazz. And so he's bringing up and saying, Judge, you're the one that said this. And then the court goes, yeah, but the question is, why was the lawsuit filed? And then the judge says, an objectively baseless lawsuit can be retaliation, but it isn't by definition. And then he says, it could also be, and I put in parentheses, a function of a lawyer providing bad advice. So help me with that. That's what he was telling Gottlieb to do. But Gottlieb went right back to the same arguments. And so I put my notes, kept insisting that certain claims were legally and factually frivolous and subject to sanctions. That's how he sees the complaint, right? He thinks that they're frivolous and subject to sanctions because, if you guys remember, on that sanction on the Rule 11, he did reprimand certain defendants that shouldn't have brought that claim. Like, it didn't apply to all 8 of them. And they wrote up the lawsuit like it was all 8 of them. And so this is important because Ellen makes a really good point. And this is what I was taking from when I was sitting there, was like, he keeps saying, like, because you did that Rule 11 reprimand and because they filed a lawsuit, I'm merging these two things and saying they were wrong. They were wrong because you said they were wrong in some pieces of it. That was the gist of what I took away from that. And then they brought up that the judge should give the jury some instructions on that. And then he said, I put examples, the website and the text regarding the website, where Brian Friedman says, we'll do the website so that it's covered by litigation privilege. And he was saying, like, that's wrong. And so the lawsuit did more than just defend. Like, that was my takeaway from that. And then the judge says, this is where he tells them, tell me, if the defendant submitted papers to the court, they filed something with the court saying that Lively's accusations were false and she had desire to gain control of the movie and that Lively can't be trusted, would that be subject to a retaliation lawsuit? And Gottlieb says, the court found that accusing someone of a tort causes distinct harm. So I think that was the whole, like, I don't understand this meaning, guys, of like a tort and how it causes harm. I think I understand it very, I guess, in general, but not enough to explain it to you guys. But that's the gist of that part. And then and I put, they do this dance a little bit more. more at one point, the judge says something along the lines of, so if they had not filed a counterclaim and they made these statements just like without a claim, would that not be retaliation? Because Gottlieb was saying, because they filed the claims and they're trying to make it privileged because of the text of like Brian Freeman saying, oh, we're going to do the website because it's privileged. And they made those statements, that's retaliation. So the judge was like, well, had they not filed the claim and it still made the statements, is that retaliation? And then I think I wrote how he finishes it off. He was like, hold on, let me see what I wrote here. Okay, so I put, if the underlying filing is baseless, the privilege doesn't shield retaliatory conduct built on it. That's essentially how he finished off that statement. Yeah, but essentially the court kept harping on this. In my opinion, the way that Gottlieb made the arguments is he was trying to say, because you reprimanded Amir, it automatically means that they did this from retaliation. And when the judge was like, no, like it's not by definition that it is. It could just be a function of this. So like help me think of these other possible reasons why someone could file a lawsuit. And then also they brought up letting the jury like look at this, and he was like, oh, they don't need to decide that. They just need to decide like how much harm did it cause Lively. And he's like, no, because I would have to let them defend that. That was the overall song and dance that they did. Okay. Then Ellen came on to rebuttal. And that's when she started, and he's like, you got 5 minutes. And then he let Ellen start, and then she started talking. And then he was like, wait, Miss Garofalo, you actually have 10 minutes. And then she went on to make her arguments. And then she said, when can a defendant's complaint be retaliatory? Like, and she's like, only when it's totally baseless and frivolous and in bad faith. And she cites McSweeney. And I if you guys know Sarah Yarn and Order, she's brought up this, she's analyzed this whenever it first came up in the case, which is Judge Lyman's own case with Bravo and the girls and Andy. I don't remember what the guy is, but she also filed a retaliation thing, and then the judge told her a counterclaim that is not subjectively baseless is not retaliatory. So Ellen is bringing that back into the discussion for her rebuttal arguments. Guys, if I missed any questions, let me know. I'm like so focused on just trying to get through it because there's a lot more slides. Like we're halfway point and we're like an hour and a half in. So if I missed any questions, I'll stop after this slide and then we'll go through them. Okay, so then she says the defendants were simply refuting Lively's allegations and showing that she is not truthful, and that's fair game. I like that she said that and she pointed that out. Oh, thank you, Christina, for putting in the comments Sarah Yarn and Order's YouTube page. And then the judge told Ellen that she had 10 minutes. Okay, yeah, that's where she stopped in and said, hey, you actually have 10. Okay, and then most defendants can file. So Ellen continues and say, most defendants can file counterclaims. Gottlieb's reading that a defendant cannot come to defend their case, I think she said, like, baffles her. Like that, I think that's what she said there. And she's like, Gottlieb's argument is that any defense or any criticism would fall under retaliation prohibitions under FEHA and Title VII. And that's what I was taking away from Gottlieb's argument. Like automatically, because the judge was like, what if Lively lied? They can't defend themselves. And he was like, well, that's not the case here because you reprimanded them and you said she's protected and that she had litigation privilege. But in the gist of it, that is what he's arguing, is that any defense or any criticism would be retaliatory. And I don't think that he convinced the judge otherwise. At least that's not how it felt. Rule 11, she did say Rule 11 has a different standard. And if you guys remember, the judge told her not to spend time on that. So, but she did say, even if statements were made in good faith. I don't know the distinction in the standard about objectively basis and objectively unreasonableness, but that is something that she did argue. And Gottlieb, oh yeah, this is I really liked her argument because that is exactly what I took from it. Gottlieb is trying to meld these together. These things that happen in this case, he's trying to make it together. Rule 11, because they got reprimanded on those few defendants that had nothing to do with the claims, he's saying that's automatically retaliation and should be lumped in with this. But she used the word meld. She's like, Gottlieb is trying to meld these together. The irony is that Lively is asking the complaint to be introduced as evidence. Okay, so here's the part that I had to Google and try to understand why they were making those arguments and put Lively suggesting. I think this is just my own research, guys. This is not what was said there. But I put this to help with this discussion, which is Lively suggesting that defendants would not be able to show how many of the allegations are factually true. But by bringing that claim in through the door, because she's opening the door for that, to the very thing she says that defendants did in the discrimination lawsuit shouldn't be able to raise. So Lively saying, you shouldn't be able to raise a lawsuit against me because that's discrimination, that's retaliation automatically. But then by bringing it into this case, they got to continue to defend it. So they're going to be doing the action that she doesn't want them to do or she thinks is wrong. So that doesn't make sense. And I think that the judge agrees. I really did feel that way when I was there. Garofalo continues that she's baffled by the argument, yeah, and that it's inconsistent with case law and makes no logical sense. The court's Rule 11's, oh yeah, she did say the court's Rule 11 rulings were very narrow, and Wayfarer was not subject to it. So meaning their lawsuit was not baseless, and it has to be considered totally baseless for it to be considered not protected under the First Amendment. So it's like certain plaintiffs may not have had a standing. That's what she said. She said certain plaintiffs may have not had a standing, but that doesn't mean the claims were baseless. Okay, that was the biggest takeaway from that rebuttal argument. Only because he reprimanded the attorneys for bringing all of those claims under all of the plaintiffs, and that some of them did not have standing, does not equal that the claims and the totality were baseless, which is the standard that they have to reach. Oh, sorry. SGAX. I don't celebrate Mother's Day, so I won't be able to share that, but I'll tell them to listen to Bocce's music. And I'll share Bocce's music with them. May not have had standing. Okay, so this question may not have had standing. If you remember, the judge in the Rule 11 sanctions, he denied some and accepted, or how what's the word, denied and granted some of the Rule 11 sanctions that Ryan Reynolds and Blake Lively filed against Wayfarer, Tag, Sarowitz, Jen Abel, all of them. And what Garofalo was saying is, like, if you remember, the judge in that denial and granting of some of those things, he said, like, these certain claims that Wayfarer made against Lively, like Wayfarer could, Justin Baldoni could, Jamie Heath could, but Steve Sarowitz really shouldn't have been in that part of the claim. Jen Abel shouldn't have been part of that claim. And I think Melissa Nathan shouldn't have been part of that claim. And Tag shouldn't. So he's like, I'm not going to sanction you, but I'm going to reprimand you for doing that. And so that's what Garofalo was saying, is like, only because those few plaintiffs, those few people didn't have standing to bring that specific claim against Lively or Reynolds, that doesn't mean it was completely baseless, which is the standard that they have to reach. At least that's what I took away from it. Yeah, we need to have a speaker. Okay. And then I had to look this up. So this was not discussed in the court. I'm just bringing it up because it may be helpful to understanding the other parts that are going to happen in the next set of arguments, which is punitive damages. And so I put in here in the presentation, like, this is just a Google search. And the punitive damages argument that would help in understanding the rest of the stuff. And one, what they were trying to do in this section of the arguments is bifurcate, which is do this thing, separate the trial in two. Phase one, liability. Did defendants do something wrong? Did they cause harm? How much in regular compensatory damages? That's phase one of what they're trying to do with the trial, to split it into two phases. And Lively does not want to do that. And phase two would be punitive damages. If defendants did something so bad that they should be punished beyond just paying for the compensatory damages, the harm. Punitive damages exist to punish and deter. So that helped me understand a lot of the arguments that were being made. Wayfarer wants it split in two, and Ellen goes into the reasons why she wants it split in two, and she makes, again, very clear, to the point, concise comments. And Lively's like, no, that doesn't work for us. We want to do it all at the same time. And then when we go through this information, your guys' thoughts should be like, who's making more sense on should they split this into two arguments? So that's, hopefully this is helpful. Bifurcation. Okay, so this is Ellen's arguments. She was at the podium and they were like, well, might as well start. And why the defense wants it. Very short and sweet. I wrote very little. Court, what is the prejudice if the case is not bifurcated? That was a question that was asked. Garofalo says, she said something like, well, I got to admit, now that most of the defendants are no longer part of the case, the prejudice is much smaller. But she goes into saying financial info before liability is found is still prejudicial. So she's like, even though it's a little bit, it's still prejudicial. Thank you, Anna. Appreciate her, or Anna V. And then she says, wealth evidence should not be relevant to the jury. She's talking about that, unless punitive damages phase is reached. Okay, so if defendants did something wrong, and if they did something so wrong, then you do that. So she's saying we shouldn't even get to this if they don't even find that the defendants did anything wrong. So she says it will save the court time from having to try punitive damages issues altogether, right? And if they don't bifurcate, if they have it all together. But she's like, it could be confusing or misleading for the jury. And then she finishes off with, it's general practice. And that was my big takeaway. So it seems like this is typically what's done. And that's why she's for it. And again, it was very brief. And then it went into Nayum Rim, which is Blake Lively's attorney, the new one, arguing otherwise. And she went, yeah, it's only one slide. I started getting tired by this point, so my notes are a lot less. Thank you, Mary. I appreciate everybody here. Hopefully this is helpful to you guys. And I will add it to the website. But please keep in mind, I'm not an attorney. I did do some research to try to see how I can explain some of these concepts, because I got the gist of it, but sometimes explaining it out loud to other people, like I just wanted to make sure that that was also clean and easy. Okay, so Nahum Rim says overall theme is wealth goes to motive, and you know they brought up Steve Sarowitz, and opportunity. Okay, yes, I am still doing videos on travel and logistics. I did do the video, I just didn't post it. And I still plan on doing the talking to the media and what you guys should do, because I know media people are reaching out to folks to get comment. I will have some suggestions. Okay, or some tips from my experience, and I didn't really like it. So, okay. Next, so she says, sorry, the court, so the judge says, punitive damages has a high standard. So what evidence do you have to support this stance, right? Like her stance. And so she goes, wealth refers to motive and opportunity because of Sorowitz's statements. And she says the statement about actually, I don't remember she said the 100. I'm pretty sure she did. Let me see. Hold on. I'm pretty sure she did. But she said, I put, quote, significant resources. I think he said that Steve Sarowitz had significant resources that allegedly enabled and motivated the campaign. So she's saying, like, this is tied to motive and opportunity, and we should be allowed to present it to the jury. And she's like, he had significant resources to launch the alleged campaign. It's more inefficient to separate or bifurcate, and it's prejudicial to Lively to try to separate, because I think it also impacts the evidence that they bring in. And then Rim said separating it is sort of impossible. Sort of. How much confidence does that statement bring? It's sort of impossible. Is it impossible or just sort of? Okay. Hi, everyone that's just joining. Okay, and then Rim says, she continues, she says, failure, she says something about the failure to investigate goes into consciousness of guilt. You know, the whole claim about, like, oh, they didn't investigate, it was SH. And so she says that somehow implies consciousness of guilt, and they want to present that. It's like they needed to show the steps were taken to prevent. They need to show, meaning the defendants need to show that steps were taken to prevent the retaliation, and whether the concerns were substantiated, meaning Blake Lively's and the other people's concerns were substantiated. I don't think they were, but that's just my opinion. I just opined that. And then she said also later goes towards the animus, which is another element, which I did not know, but she said animus is another element that they have to reach. And then the judge, question the judge asked to assume he doesn't agree. Oh, okay, yeah. He says, assume that I don't agree with you. He's like, that I don't agree with the Robbins report or bringing the other lawsuits or the other incidents of discrimination that Lively did not witness or was aware at that time. And here's where Nahum Rim kind of appeared like a little bit taken back by the question. And she goes, I'm not sure that Lively wasn't aware of any evidence at the time that she filed her complaint, or wasn't aware of any incident. Sorry, not evidence, incident at the time that she filed her complaint. And then the judge goes, yeah. I mean, there's text messages of, you know, that Lively knew about Jenny Slate. But then the judge gets back to the same question about the incidents, but like assume that she wasn't aware, because remember, she wasn't aware of everything. There was stuff that she wasn't aware of in real time. So I put that she was not aware of at that time. And Rim again kind of gets taken aback, like, I'm not sure what you're asking. She's like, so my notes is like, she answers very similarly that she was aware of them when she filed her CRD. So she was aware by the time that she filed in 2024, a year later, a year and a half later, or whatever. And if incident came after the protective conduct, then it would go to punitive damages. So she was saying if it came after the protective conduct, which she believes is when she filed her CRD complaint, then it would go to punitive damages and would go to objectively her belief that it was reasonable, Lively's thing. And I think a lot of this gets answered with, Wayfarer stipulating with the stipulation. So some of these arguments won't make sense now that they have stipulated. But yes. Is this going on a little too long for you guys? We're at the 1 minute 40. I'll try to wrap out I only have 10 more slides. I'll try to wrap out in 19 minutes. And if I missed any questions, just go ahead and drop them. I'm going to start this stream. I'm going to start that, and then I'll catch any questions after that. Okay. And that was the end of her arguments. And then Ellen goes back up there, and she's like, I understand that Lively's position that all the SH evidence is still relevant. And then Ellen says, I think the judge is going to address this issue. Now I feel like this is more tea. Like now that we know they stipulated and that they still have the MJOP, I feel like this statement, I don't know, it gives me a little je ne sais quoi to it. Like I think the judge is going to address this issue. Like maybe they're confident because she's saying Lively's position is that it's all still relevant. And Ellen's like, I think the judge is going to address this issue. And she put, the defendants disagree that it's relevant. And then she said, we can discuss when the court reaches this issue. So I'm like, yeah, this is a little bit tea. This is a little bit tea now that we know that they stipulated. Okay. And then she said, Lively, sorry, I misspelled that. Lively just explained why it's important to bifurcate. So she thinks that Nahum's arguments actually help the defendant's Wayfarer's position. She's like, she just explained to you why it's important. And Ellen continues, there's going to be an effort to continue to litigate, for example, the failure to litigate claim. She messed up. Okay, well, I'll tell you what happened. And then the judge goes, this gets corrected, but but that's how she said it. For example, failure to litigate claim. And remember, it wasn't that. It was the failure to investigate. But she said failure to litigate. And then the judge says something that made everybody laugh. He said, you said failure to litigate, but I think this case has been marked by anything other than failure to litigate. Yep. And then everybody kind of like started giggling in the courthouse. Yeah, he made a little joke. Lyman made a little joke. He's like, this case has been marked by everything except the failure to litigate. But she meant to say, I think, failure to investigate. I think that's what she meant, because that's the point that Nahum brought up. But she's like, they're going to still keep trying to fight that. And that's the whole point. It's going to waste the court's time. Remember, Ellen's arguments was it saves the court time from having to do this. And she's like, we're going to do the failure to investigate and all these reasons why they want it. And Ellen's like, look, they made the case for you as to why you should agree with us, which is they're going to try to make this longer because they're going to try to continue this claim. And they're going to take up the court's time. And then she says, Sarowitz is no longer a defendant and his wealth is irrelevant. And then she says, the court just said how exceptionally intense litigation here. I guess that's all I wrote. It kind of makes sense, but I may have missed a word in there or two. But she said something about like the litigation has been intense. So she said, would Ryan Reynolds' wealth also be relevant then? And then, oh, so she didn't say like it will be relevant. She asked it like a question. Like, would Ryan Reynolds also be relevant then? And then she said, this case is the perfect example why punitive damages should be bifurcated. And before we took a break, the judge asked if the defendants intended to contest that there was a good faith and reasonable belief for the hostile work environment, that stipulation. And they were like, oh, I don't know, we're going to answer soon. And then people kind of laughed at that too, because it was like, soon? And it was like, yeah, soon. And I'm so glad we took a break because I was fading. I mean, you could tell by my notes. I was definitely fading. Definitely needed that break. With that, I'm going to, so this is when we come back from the break, and then the judge goes into a little bit of rant. Give me just 1 second, guys. I'll be right back. Okay, guys, I'm back. Thank you so much. Thank you. And I appreciate the mods. Thank you for everyone saying to like the live, and thank you for commenting and sending me questions. It's making it easier for me to go through the notes and know that there's interest. Okay. The judge comes back. We go on break. And he's like, hey, I need to know, you need to send me 2 letters. Letter 1 needs to talk about AI for the purpose of characterization and classification. You remember that issue came up with the Mayzlin report and how some of them were misclassified, and that they're going to talk about that. He wants a letter on that. And then he's like, this isn't the only case where experts rely on some intelligence to characterize or classify materials, or some other human or non-human thing to do that. I don't know why, but that's what he said. And then he goes, it should not make a categorical difference that the testifying experts in this case rely on AI rather than humans. But he did say the error rate in the instructions. I think I put in the instructions, but and the instructions. And then he says, in the second letter is regarding Mayzlin's reputational harm and aggregation of actionable versus non-actionable statements, which is the argument that when it's because of the defensive measures that they took, that's non-actionable versus actionable, and how that can't be separated. If you guys remember a few slides back, we talked about Fabian's arguments that it was kind of just lumped in together. The court says, I'll have it under consideration that the plaintiff argued for its totality. So that's what he said. He said sealing. This is the part where he talks about the sealing and the high bar for public access. He cites the Amadeo case. And I've seen it so much in the letters to seal and unseal that I didn't know how to spell that one. And now he said, highlighted, the public has the right to access the court proceedings. And he's like, there really shouldn't be any information that should remain sealed except for compelling reasons to do so. And then Hudson says or confirms, we're not seeking to seal anything except the Heath birth video. And the Wayfarer, Ellen Garofalo, replies and says, we have no privacy concerns, mic drop. And then the judge is like, well, between the two of you, no, well, he didn't say that, but essentially he said Heath's privacy interest is out, outweighs here. So I'll mark this taken off the table or something like that. Yeah, the issue's largely resolved, taken off the table. I think I put taken off the table. So that takes that fixes that. Then he said Jed Wallace to meet with Jed Wallace and his third party people. He's like, Jed Wallace and his clients require separate meet and confer. He gives them instructions on that. And he's like, some unrelated parties that are not Wallace's clients. I think I put related, but he was just saying some parties that are not his clients and some that are his clients. And then Ellen says, oh, Jed Wallace filed something this morning. And he's like, I'm not prepared to address it without input from the parties. And then he's like, that letter is due later this week. Please meet and confer. And then he talks about the trial logistics and the microphones. And he's like, hey, the microphones, like I may not hear you when you're like not like right there on the mic, but in the overflow room, everything is heard. And he's like, so this is your warning that everything is heard. So even if you think you're far away, the overflow room, which is the second room where people that don't get to be inside the actual court where the action is taking place, they get to watch it through a TV. That's the overflow room. They can hear everything. And so he says, all exhibits need to be made available to the public by 6 p.m. the day that they are shown. So, docket updates will be there, posting the exhibits. So please make sure to check out the website. And if you're interested, follow me for that. I know I'm not the fastest or the first person to report, but I try to be very thorough so that I could give you guys as much as information and access as I have, to the case. I just think access is really important. So if you guys care about that, it would help me out a ton if you guys can follow and like. And I've already booked my flight and my stay for at least for the first week, but I do plan on staying there the whole time. So I'll have those on the website, easy to access. I'll have to make a tab or a section just for the trial, and like day 1, day 2, I'll probably get some ideas from other trial websites. Okay, I'm deviating, but please do. Please follow and make people aware of it. It would greatly help me. I don't put ads on my website because people have told me to put ads, but I care more about access than anything else, and I don't want ads to slow down your guys' download times or anything like that. So it would help me out a ton for you guys to check out the website. And if you'd like to, I do have a buy me a coffee link, and I've told you guys in the past, it's just I've taken this as my hobby money. But if you'd like to, and you guys are so generous with me, I really appreciate it. But please don't be obliged to do so. But it is there for those that want to. Okay, and then Lively says estimates 3 or 4 weeks for total for the case, and he's like, and we want for our presentation 15 days of trial time, which is 2/3 of the time. And Garofalo's like, well, we want equal amount of time. And then the judge says, I think the oh no, this is Ellen. Ellen says, I think the stipulation will make the difference here. And then they have this chat about how quickly can you get it to me, and then Ellen's like, in 24 hours, and that's why we know that that they answered that they did stipulate, and then something came up there. I don't know if I brought it up, but when she said that, she was like, I'm not sure that Lively agrees with this. And then he's like, I don't need to know their answer on that. It may be up ahead. But he says, counsel is expected to know the court technology. It will count against your time. If it's your user error, like if you don't know how to turn on the camera, you don't know how to turn on the presentation thing, like that does count against your time. And he makes a distinction. If the technology fails you, then that doesn't count against your time. Only if you don't know how to run it. And then the stipulation question comes up again. Okay, yeah, this is where I wrote it. And at first, guys, like this wasn't that interesting to me. I don't even think I had a slide, but after the stipulation, like the interaction here was very interesting to me. Question defendant raised in regard. Okay, so the judge says the defendant raised a question in regards to the number of exhibits. And then the court said that may be affected by the stipulation. And then Ellen said, I'm not sure Lively's team agrees with that. And the judge replied, I don't need an answer from them on that. That's why he said no to Ezra's letter. So had I hurried up and brought this presentation, we probably would have known. But honestly, like this little interaction made a lot more sense after the stipulation. So it may potentially be relevant to the motions in limine. That's what he said. Yes. So isn't that, yeah, I just found that so like, that I don't need an answer from them on that. He said, just do you, honey. Okay. And then the Judge Lewis goes into the exhibit list after motions in limine rulings. So he tells them what he expects. So he's like, after I give you guys my motions in limine, the parties should be ready to meet and confer. And lead counsel needs to participate on these meetings. He's like, don't leave it to your little junior associates. Lead counsel needs to be on these meetings. And he's like, if the exhibit is not on the list, not on the exhibit list, it will be excluded from trial, except in cross-examination. And then he goes, exhibit lists are due 48 hours after motions in limine ruling. And then Hudson says, we request 72 hours. And then the judge is like, okay, I'll keep that in mind. And then the judge asked Garofalo, like, you're not going to be needing more time than the 72 hours, right? And Garofalo's like, nah, we can do it in 48. And then he's like, okay, well, then meet and confer on your own. But if you need me to help you set times about this, he's like, I can. He's like, but let me tell you this, it's better that you guys work this out because anything I come up with may make both parties unhappy. He said something like that. And then he said by 2 p.m. each trial day, the party has to let the other know what the witness list is expected for the next day and which exhibits are going to use for the next day. And he's like, and I need you guys to meet and confer by 6:30. And he's like, and then if you guys can't agree to stuff, then I need to know every day by 8:30 what those objections are. So every day we're going to have something on the docket because I doubt that they're going to come to an agreement. Hi, everyone that's just joining. Okay, I'm trying to get through this and wrap up in the next 2 minutes. I think I only have 2 more slides. Okay, thanks for bearing with me, guys. The court rules on 1362. You guys already know this. And again, I'm sorry, I'm just bringing it so late to you guys. But it says mixed motive affirmative defense, right? Lively doesn't want Wayfarer to have mixed motive. And I always forget what the first one is, but there's two affirmative defenses that he's like, they shouldn't have the right to have them because they waived them. And then Wayfarer's like, no, we didn't. Like, we have the right to use it because blah, blah, blah. And they wrote that letter. And you can look this up in docket updates. Let me show you guys real quick how to do that. Okay, so if you guys go to docket updates. Okay, so if you guys go to docket updates and like, let's say you type in 1362, it should pull up the argument. Okay, so that you could pull up that docket. Now, usually what I do with these posts, it tells you what it is in my headline. I try to summarize what this argument is. And then I put a related post section. So you know what their original argument was, what Wayfarer's opposition was, what the judge ordered. Most of my posts do. Sometimes I forget to come back and link the other stuff. But this is why the website is there for you guys to help you figure out what was said, what was argued, and why. So
if you look up 1362, which is what the judge decided, oh, it actually brings you to the latest, but this is the first time. If you scroll all the way down, you'll get to the first time it's brought up. But either way, it's all linked on the last one, because I try to go back and link these arguments. So this is her arguing it again after the court, after this pretrial hearing, after the judge said no. This is their other attempt to do it. And then Wayfarer's opposition to that, and what the judge ruled, and any content creator around that breaks it down for you guys. I link all that in there. And hopefully that is helpful to you guys too. Okay. And then the judge says, no, I'm going to reject Lively's thing. The court will give a mixed motive jury instruction. And he cites case law, Alamo, and something else. I didn't get to write down what it was. And then he says there's no prejudice to Lively because the defendants argued this, or asserted that their conduct was not retaliatory for the complaints, but they were protecting themselves like long before. And that's just the gist of it. That's not verbatim. It's just the gist of it, of what he was saying. He's like, no, Lively has had plenty of time to know that that they've been arguing this since day one, and you've had chances. And then Hudson asked, can we propose an alternative jury instructions? And the judge's like, yeah, sure, do it by the end of the day. And that's when that was their second try, that if you look up 1362, you'll pull it up and see it. Regarding the Daubert hearing, this is the trial, the hearing that's going to happen on May 8th, on Friday. He's like, any other issues we're going to address at the end of that hearing. What else should I address right now? And Hudson's like, well, the spoliation is still outstanding, and that'll affect the exhibit list. Remember, they're saying that Wayfarer spoiled evidence. And then the judge goes like, I know what's on my table to judge, thanks. He said something like that, like, I know what's outstanding, like, you don't need to tell me. But he's like, but that'll affect the exhibit list, voir dire, and jury questions. And then Hudson says, oh, can we do a trial run to make sure that the court technology works? And the judge is like, yeah, that's a great idea. Get with my court deputy. And Garofalo says there's an issue with the witness list. Remember, the defendants are saying, like, remember, Lively has 844 exhibits, and that's like a 9-month trial, people have said or claimed. So they're like, it's extensive. So Garofalo says, based on the two things, the Daubert and the stipulation, that may be narrowed. And the judge said, I think that's right, but let's discuss at the Daubert hearing. So the stipulation did change it. But he also said maybe or maybe not. I don't know what he meant by that, but it maybe because he said, I think that's right. And then he said, let's discuss at the Daubert hearing. He's like, maybe or maybe not. I mean, I think maybe he has to just be neutral in his responses. I don't know. Maybe he was correcting. I don't know. But that's what I wrote there that he said. And then this is Michael Schachter. He's Blake Lively's new attorney. He came in and said he had an issue with questions not being asked. Oh, thank you, Jungle. Yes, hopefully you guys make use of that. I try to link every resolution to each thing, like Wayfarer's arguments, Blake Lively's stance, and judge's ruling. Okay, guys, I'm sorry. I'm over time, but let me just finish. I have two, I think, what? 2 slides. Okay. But thank you, Jungle. Appreciate that. The specific questionnaire. So he says, we request a written questionnaire to streamline the process. He's like, we think it saves the court time. Obvious biased jurors before the court questioning. Guys, by this time, I'm kind of fading, so my notes are a little light, you can tell. And then it says, cites Barrett case. And I think this is Schachter's own case, because the way that he talked about it. And then he cites Combs' trial before judge, and I had to look this name up. I put Combs, and I thought it was Supermanian, but it's Subramanian. And then he goes, the judge says, Live Nation didn't use that approach. And Schachter's like, oh, I'm not familiar with that. But anyways, he continues, and he's like, I don't know what I meant by ABA now. I can't remember. and he's like, encourages questionnaires to identify bias. I don't know why I wrote that, guys. I'm sorry. Yes, thank you. Thank you for liking the stream. Thank you for helping me out with that. And then he goes, this is Lively's attorney. He's like, we're going to ask you to reconsider all these questions. And again, if you guys go to docket updates and type in jury questionnaire, it will come up with any letters that have to do with the jury questionnaire. And he's like, 22, 23, these are all the letters, these are all the questions we want you to reconsider. We think that these numbers or these questions go to the heart of the bias and partiality. And he's like, he said something about these jurors may have like strong pre-existing views on the claims at issue. Maybe common questionnaire surfaces them. Oh, okay. So he's saying like this questionnaire helps surface these really strong pre-existing views. And he's like, we could put it in 4 buckets. And he's like, 1 that's challenged for cause, 2 that's based on existing questionnaire, 3 a list of disagreements that the government felt that should be challenged but not the defense. And then he goes and sings for the plaintiff. I don't know what that means, but hopefully that makes sense to you. But essentially, I think he's just like having them revisit how they're going to ask the jury questions. And he's like, the court suggests adding, the judge says, I think adding social media to the question of like, how do you get your news? Like maybe, maybe that does make sense. Like that, maybe that's something that I could add to the questionnaire. And he goes like, I don't think it's possible to find jurors that are not on social media, except like the judge, like he's not on social media. And then he cites, Judge Lyman cites Carroll v. Trump and says something about like the questions that they had were something similar. And he's like, he said in the Carroll v. Trump, he said, could you put it out of your mind? Like if you do have this strong bias, if the juror answered yes, then they're qualified. If they answered no, then they have a follow-up question instead of automatically ruling them out. Like that's the gist of what I understood from that section. So could you put it out of your mind if you do have a bias or a strong view on something? But Schachter wasn't letting up. The court said, he said something like, the jurors who recognize the case may answer untruthfully. Because he said something like, if they see Blake Lively or Justin Baldoni, like they may be more inclined to answer untruthfully because they know it's that it's celebrity case. And he's like, and I know that this case is going to attract significant attention. And he said something that the written questionnaire wouldn't reveal the sophistication or education levels accessible in a person not through written questionnaires, according to the court. Like that's what he said. And then he's like, do you have anything that I need to reconsider? I think he asked the defendants if they had anything, and they were like, yeah, if you would reconsider these 5 questions. And they list them out. But what Schachter essentially wanted was like, do you read it? It ends with us. Did you watch the movie? Do you know anything about this case? And the judge was like, I'm not sure. I'm not sure if it should be that detailed. Like, look at the questions that we did for this case, the Carroll v. Trump, and I think that'll take care of it. So I don't know. It didn't sound like he was convinced about Schachter's arguments. And then key open questions heading to trial, bifurcation decision, the Daubert rulings, which is this upcoming Friday. The stipulation has been taken care of. No time limits had been set. I think that's going to be taken care of at the end of the Daubert hearing. 47.1, the judge ruling on 27.1. How long will the case be? The AI letter and the second letter about Mayzlin's non-actionable versus actionable stuff. And so these are the key open items. And that's it, guys. That's all I have for today. I'm sorry it took me so long, but hopefully this breakdown is helpful. Like I said, I may not be the first, but hopefully I'm thorough, and it gives you guys a little more access to what was said at this hearing, because we won't know until the transcript becomes available publicly 90 days out. So that's all I have for you guys. I appreciate everybody joining me. If you guys could like my live, check out my website. Again, if there's anything else you guys need or questions or suggestions, I am checking the suggestions daily. There's some stuff that I can do and some stuff that I can't, just because of time and things that I want to get done before the trial. But I am reading it. And then I also noticed that somebody sent me a comment about my YouTubes. I do have to change a setting to allow you guys to see the replay or like the comment replay. I need to figure that out, and I will do it. The artwork is from Art in Court. She did this on January 22nd. And I approached her about it, and that's why I have her watermark on there, as well as docket updates. So hopefully, yeah, I want to put this on the website so you guys can see it. I thought it was really neat. That's Judge Lyman. That's Gottlieb. That's Bruno. I think that's Ezra. That's Bach. That's Shapiro. That's Ellen. And that's Brian Friedman. And I think that's Michael Schuster. And Kevin Fritz sits back here, right here. So he's not in the photo. Where's Josh? Where's Josh? Yeah, it's nice artwork. Yeah, she's Art in Court. She does sell her works. So you guys, I don't know if she has an Instagram or social media. But if I put it on the website, I will link her so that she gets all the credit and recognition for her really cool artwork. Do you guys have any questions? Oh, thank you. Christina, thank you so much. Now that I have you as a mod, that's been so helpful. Thank you for putting the website links and Sarah Yarn and Orders link. That was so nice and hopefully helpful to people. Which says, whenever I see the hearing art, I see Lyman as Liz Lemon's little boy lawyer in the man suit. I don't understand that reference. But yeah, that's Judge Lyman. Where's Josh? Let's see. What? Docket Updates as a dating site. So I need to email it to myself so I can do it at home. That's too funny. Yeah, so check out Docket Updates, guys. Oh, no. Okay, so all of these people they put the defendants behind here. So anybody that was there for Wayfarer, I think this is Mitra. Mitra was sitting there. I don't remember this guy's name, but he's with Wayfarer. They let them sit right here. And then they put at least for this hearing, they put the journalist right behind them. And then NAG and LGA, we were back here. Like, can you guys see my mouse or no? Probably not, now that I think about it. But the person behind Bach, I think that's Mitra. Ahurian. Oh, thank you, Leo, for liking the live. I really appreciate everyone. Thank you so much for joining. Hopefully you guys benefited from it, and I'll put it up on the website probably today or maybe tomorrow. But again, check out the website. I have uploaded all the depositions, so they are updated. So check that out, okay? I got to let you guys go, but hopefully I'll be back soon. Bye, guys. Thank you. Thank you, Mary.